And I'd like to call to order this special meeting of the Board of Education. The purpose of our meeting is the Level 3 grievance related to the school psychologist, which was brought to you through memo number 57. I would look for an approval of the agenda.
I move approval of the agenda.
Second.
Thank you. Moved by Seth and seconded by Nikki. Any discussion? All those in favor, please say yes.
Yes.
Any opposed, same sign. Okay, thank you. Our agenda is approved. Moving on to the level 3 grievance. I'm going to follow a similar format that we used at our last special meeting. I'm going to have the FEA first present the grievance to us, and then Mr. Thompson will respond to that, and then the FEA will have an opportunity to have a reply. So as soon as you're ready, please come to the podium. Thank you.
There we go. Members of the Fargo School Board. My name is Mike Eierman. I am NDU General Counsel. Tonight I am accompanied by FEA President Grant Kraft, NDU President Nick Archuleta, NDU Executive Director Chad Oban, and NDU Staff Representative Dave Marquardt. I appeared in front of you about 3 weeks ago on an issue regarding the issuance of a contract to a special education teacher, and I am back in front of you in regards to the issuance of contracts to school psychologists that are not in keeping with the FEA negotiated agreement. The level 3 grievance that's been brought to you by the FEA is that they are grieving the removal of the school psychologists from the FEA contract. The FEA takes the position that their contracts are covered by the FEA negotiated agreement and have been issued pursuant to that negotiated agreement for a number of years. The school district takes a different position. However, in a letter received by Superintendent Gandhi, it indicates to us that he acknowledges that the contracts have been issued pursuant to the FEA agreement, and I will point that out to you in his correspondence. So the basis of this grievance is, have the school psychologist contracts been issued pursuant to the FEA negotiated agreement? And the answer to that question is yes, they have. In order to gain more information about that particular issue, I had Mr. Marquardt make an open records request to the school district to receive all of the school psychologist contracts that the Fargo School District has issued over the last 10 years. In response to that open records request, we received 57 different contracts issued to school psychologists in the last 10 years. All of those contracts are identical to teacher contracts that have been issued to the 900 or so teachers that are employed in the Fargo School District. So from a past practice perspective, it is clear that the Fargo School District has acknowledged that school psychologist contracts are covered under the negotiated agreement. And I think if we went beyond the 10 years, if we went back even further, we would collect contracts that clearly show that they were issued pursuant to the FEA contract. The salaries that have been paid to the school psychologists over those years are based upon the salary schedule found in the FEA negotiated agreement. Those salaries are determined based upon the education of the school psychologist, how many credits they have above their master's, whether they have their doctorate, or how many years they've been teaching. But there is a matrix, of course, in a salary schedule, and you can look at the contracts that have been issued to school psychologists, go to the FEA negotiated agreement, and pinpoint exactly where they fall on the salary schedule. That's not a difficult task. So the issuance of the contracts to the school psychologists in this school district from the past practice is that they are issued just like the teachers' contracts are issued. As you know, and as is the practice right now, school districts cannot issue contracts to teachers while negotiations are going on. Over the past several years, though, I went in and checked when school psychologist contracts were issued during a particular year. And I found that those school psychologist contracts were issued at the same time teachers' contracts were issued, dependent on the status of negotiations. For example, in 2016, the contracts to the school psychologists were issued on April 26th of 2016. Negotiations had concluded. In 2017, they were issued in August. In 2018, they were issued in September, after the school year had started, because that's when negotiations had concluded. In the contracts for 2019, because of a lawsuit, were not issued until February 27th of 2020, the same time teachers' contracts were issued. In 2020, they were issued in April 27th of 2020. In 2021, school psychologist contracts were issued on October 26th, 2021, to coincide at the same time when teacher contracts were issued. In 2022, they were issued on April 23rd, and as 2023, they have been issued this summer, which we believe is another violation of the law, because if they are considered teachers under the contract, the issuance of contracts during negotiations is suspended. So the past practice, it sure looks an awful lot like the fact that the Fargo School District has treated these school psychologists as teachers based upon their issuance of contracts. And when I looked at those contracts, they are given 14 days to sign and return those contracts, just like teachers. Years ago, when I first started in this job, teachers had 30 days in which to sign and return their contracts once they were offered. The legislature deemed it important to change that date, and they changed it to 14 days. So when teachers get their contract offers, they have 14 days to sign them and return them. When you look at all of these 57 contracts that I just made reference to, your school district informs school psychologists that they have 14 days in which to sign and return those contracts, just like teachers. If they weren't teachers, they could have demanded those contracts be returned the next day or in 2 days. But they gave them the same privilege that teachers have under North Dakota state law. In your board packet, I believe you have all of these documents, and I'm starting with the document that was issued to Mr. Kraft by Superintendent Gandhi on September 19th of 2023. Besides the past practice, excuse me. Do you want that projected? Yep. Okay, he's gonna.
Is it up for you?
We're seeing the same thing.
Find his,
Are you on extended screen? You're very smart.
Okay. I can get rid of this thing, right? Okay. Okay. Besides the past practice that I've just outlined from you, if you look at Superintendent Gandhi's letter to Mr. Kraft in the third paragraph, after considering all the information presented at the September 5th, 2023 meeting, and the information provided to me in the attached memo from Mr. Thompson and Ms. Brander, I am upholding the decision to move the school psychologists from the negotiated agreement. That's a concession, in my opinion. That's a concession. Superintendent Gandhi can certainly speak for himself, but in the letter that he sent to Mr. Kraft, it certainly appears that the school psychologists are being removed from the negotiated agreement. If you go to page 6, this is the memo that you received from Ms. Brander and Mr. Thompson. In the first line, it says school psychologists at the Fargo Public Schools were historically paid in accordance with the negotiated agreement's wage schedule for teachers, even though it was not required. That's the rub. That's the issue. That's the dispute between the FEA and the school district. We think under North Dakota law, it was required. If you go in the paragraph just below that, it talks about Article 1 of the negotiated agreement. We went over this the last time I appeared in front of you, but this is the recognition clause. And the recognition clause that the FEA brings forward and that the board approved dealt with the situation where the FEA takes the language right out of the statute in regards to who they can represent in the bargaining unit. Employees licensed to teach by the North Dakota Education Standards and Practices Board, and or is an important word because or then means there's choice, there's different categories. Approved to teach by the North Dakota Education Standards and Practices Board and employed primarily as a classroom teacher. Now, I know that one of the concerns is that, school psychologists really aren't teachers. They're not in a classroom and therefore they don't fit well into the definition of a classroom teacher. I spent last night looking at on YouTube, I looked at your meeting from March of 2020 when you had to deal with the issue of whether school counselors were covered under the FEA agreement. And after about an hour and a half or an hour and 45 minutes of discussion among board members, and Mr. Marquardt was here and the FEA president was here, and there was quite a discussion. The board eventually made a motion and determined that school counselors were covered under the FEA negotiated agreement. So this board has a precedent. You've established a precedent of acknowledging that there are a group of individuals who are not classic classroom teachers, but are still covered under the negotiated agreement, and they're counselors. And as we stand here today, I'm sitting here saying that now you have another group of school psychologists who have all of the same licensure duties, and they're not in a particular classroom, but they're covered by the FEA negotiated agreement, not necessarily because I say so, but because your school administration over the last 20-some years has said that they are. You go down to I want to go down to the Hilton case. Okay. We talked about the Hilton case last time, and in your lawyer's opinion, they've cited a portion of the Hilton case. And as you'll recall, the issue in the Dale Hilton case was whether he, as a school counselor, was part of the Center Education Association bargaining unit, and the Supreme Court found that he was. And in this particular paragraph, that's where the Supreme Court makes the determination as to whether or not a school counselor was part of the negotiating unit. And as you look at that, you get about halfway down, it says, thus it appears, and this is an Attorney General's opinion, and I indicated to you the last time that this Attorney General's opinion was 1974, was written by Gerald Vandewaal, who eventually becomes the Chief Justice of the North Dakota Supreme Court. Thus, it appears to me that the requirement of being employed primarily as a classroom teacher was to distinguish the individual from an administrator. So in essence, what the Hilton case stands for is, under North Dakota law, if you want to negotiate with a school district, you fall into one of two categories. There's just two. There are teachers and then there are administrators. And in the Hilton case, what the Supreme Court said is, well, he may not be your classic definition of a teacher, but he sure isn't an administrator. So then he's got to be a teacher. By default, he's got to be a teacher. Now, the memo that was presented, and your lawyers can speak to this when I'm done, but you're in your lawyer's opinion, this all changed in 2001. That the legislature redid the law in 2001 because the law in the Hilton case was pre-2001. And in 2001, the legislature decided to change the definitions and all the rest of it, and basically impliedly overruled Hilton, which I would totally disagree with. Your lawyers cite to the legislative history, they cite to other situations, and basically they say on the page that I'm on right now, if they meet two elements, they're being licensed or approved to teach by the Education Standards and Practices Board and employed primarily as a classroom teacher, then they can be considered as teachers. And then your lawyers opine that school psychologists in the Fargo School District are neither licensed nor able to teach, nor are they primarily employed as a classroom teacher. And that's the discussion you had a year and a half ago about school counselors. And you indicated that school counselors were covered by the negotiated agreement. So that distinction that's being made in this really doesn't make any difference. So I appeared in front of you about 3 weeks ago and I told you that in the rewrite of the education code in 2001, there weren't supposed to be any changes made. Okay, the substance was to remain the same. How do I know that? This is an excerpt from a case called Kenmare Education Association versus Kenmare School District, another case of mine which I took to the Supreme Court. And in paragraph 30, the Legislative Assembly created an omnibus bill that revised several provisions of the Education Code previously found in Title 15. The bill was designed to reword certain provisions of the code dealing with teacher representation and negotiation, but not to make substantive changes. That isn't because I said so, that's because the Supreme Court says so. And actually, when you continue reading this case, the NDEA back at that time tried to make a substantive change and the legislature wouldn't go for it. The change that is being urged by your legal counsel and your administration is that somehow in 2001, they talked about school psychologists, but they didn't put them in the law, and so that's the change. Well, I would totally disagree with that because of this fact. Teachers used to have 30 days in which to sign and return their contracts. North Dakota School Board Association and other school boards got together and convinced the legislature to change that down to 14 days, and they would have announced that to school boards. Well, there's a big change. There's a huge change in the law. Now it's 14 days. Now, the latest change was negotiations have got to be wrapped up by July 1st, right? Big change. NDSBA tells everybody that's going on, okay? So as we look at this issue as to whether or not school psychologists were taken off of the law in 2001, one would think that the School Boards Association would have announced that to every school board in the state, and all the school boards in the state would never have negotiated with education associations on behalf of school psychologists. They would have cut them loose. That would have been back in 2001. Your school board never cut them loose. As a matter of fact, the only school district in the state that doesn't negotiate with an education association, which includes school psychologists as part of the bargaining unit, is Bismarck. Everybody else in the state does. So my point is if the law really changed in 2001, there had been a pattern back in 2001, 2002, 2003, maybe 2004, where all of a sudden school psychologists were out of the bargaining unit. It never happened because the law never changed. It's the same law that was decided when Dale Hilton's case went through. It's the same law that was decided by you a year and a half ago when you decided that school counselors were part of the FEA. So according to your administration and your lawyers, a change took place 22 years ago. And Fargo never changed their practice. And Grand Forks never changed their practice, and Minot never changed their practice, and Dickinson and Mandan and every other place that hires school psychologists, none of them changed. So did the legislature overrule Hilton in 2001 by changing the statute? The answer is no, it didn't. Actually, what's happened is, I think, the guesswork in this whole situation has been taken away by the legislature. Let me show you the next slide. If you go, this is the definition of teacher. Teacher means a public, number 5 on your slide. Teacher means a public school employee licensed to teach by an Education Standards and Practices Board or approved to teach by the Education Standards and Practices Board and employed primarily as a classroom teacher. Okay, that's the definition. To teach. So the word in there is, the key word is teach. In 2001, this is a different title. This is 15.113. This is a different chapter of the Century Code. This is the chapter that creates the Education Standards and Practices Board, which licenses all the teachers and other school district employees in the state of North Dakota. This is 2001. Go down to subsection 3, the profession of teaching. Means the provision of a public school district, the provision in a public school district of teaching services, administrative services, or other services which require licensure by ESPB. That's in 2001, the same year that the legislature modified Title 15. In 2007, the legislature then went in and just changed that provision that I just showed you in 2007. Now the profession of teaching means providing services in an approved school as a teacher, counselor, librarian, curriculum director, or supervisor, speech or language therapist, school psychologist, special educator, or administrator. The profession of teaching, let's go back. There's 2001. There's 2007. This is 2023. There they are. School psychologists. The profession of teaching, which means that they teach under the law. Maybe not in the conventional sense that you think about, but under the law, they teach. The legislature listed them as teachers. School psychologists, the profession of teaching. So when you go back to the definition, teacher means a public school employee licensed to teach by the Education Standards and Practices Board. That would be a school psychologist. It's been that way in this school district for a long time. I can go back farther. I bet I can go back to the 80s or the 90s, and I can come up with contracts that look just like teacher contracts. Here's the point. The FEA did not take this grievance on because we're anti people making money. I spent 36 years of my professional life trying to get teachers more money. I'm all for it. I am absolutely all for it. I've stood in front of lots of podiums in the Supreme Court and in the legislature and all sorts of places saying teachers aren't paid enough, and that would include school psychologists. That's not what the issue is. I'm all for school psychologists getting more money, but I'm also all in favor of a process that the legislature created to make sure that that gets done through a negotiation process. All of a sudden, this summer, issuing contracts to school psychologists off the schedule is not the process. Your school district doesn't have the unilateral right to break state law and especially the past practice. And I understand, well, we just kind of did it as a matter of convenience. Well, it sure doesn't look that way. Not after all these years. Your contracts for your school psychologists look identical. And as a matter of fact, they call them teachers. Your contracts call them teachers. So the grievance that the FEA has brought wants you to return those school psychologists back to the salary schedule. And then once negotiations are completed, they will get their raise just like every other teacher in the Fargo School District. That's how it works. In the legal memo that your lawyers sent to you, there is no reference to 15.1-13. There is no reference to the teacher licensure statute. And they'll tell you it doesn't apply. I don't know. It sure looks like it applies right there. The profession of teaching means services provided by a school psychologist. There's no guesswork here. We don't have to guess like we did in Hilton. We don't have to guess. It's right there. When you combine that statute with the negotiation statute, the key word is teach. NDU didn't come up with this. The Fargo School Board didn't come up with this. The legislature came up with this. So in essence, what the FEA is trying to do is to enforce what the state law says. Going to get school psychologists more money? Go through the process. Thank you.
Thank you, Mr. Geierman. Mr. Thompson, if you're ready.
Yes, thank you. Madam Chair and members of the board, my name is Seth Thompson, represent the district on this grievance. And the issue we're focused with here today is, are school psychologists within the statutory definition of teacher or allowed to be within a bargaining unit for purposes of collective bargaining? Said differently, it's our teachers within the collective bargaining statutes of the North Dakota legislature has enacted. I think it's worth pointing out and making a distinction early on in this. We've had a lot of discussion about whether or not the teachers or the school psychologists are, quote, on the contract or not on the contract. And Mr. Geierman has made some points about how if you're paying them in accordance with the contract or doing different things like that, that's some sort of admission or whatnot that the school psychologists are within the bargaining unit. And I would respectfully disagree with that. And one of the main points I would make is take any other collective bargaining situation, whether it's the rural electric co-op out in the area or whatnot. It is not uncommon for wage increases to wait until a bargaining unit has taken care of and done its negotiations for them to apply to the non-bargaining, or for other terms and conditions that have been bargained to apply to the other non-bargaining. That's nothing unique or anything new. It's just the reality of labor relations, and the fact that teachers, that there was maybe some following of a salary schedule doesn't mean anything in and of itself that they are actually within the bargaining unit. There are some distinctions to note with respect to the school psychologist. If they were dovetailed and meshed in with the actual contract in the bargaining unit, you would think that some of the provisions would be exactly the same, but they're not. The length of days for school psychologists is different than what it is for teachers in the negotiated agreement. There are differences in the working days, planning and prep time, hours and work, and different things like that. So these things aren't the same. So even though maybe school psychologists maybe were paid following some form of a schedule or whatnot, isn't an admission or anything that they are in the bargaining unit any more than any other non-bargaining type situation. But when you look at the legal issue about why the school psychologists are or are not within the definition of teacher, or they have the ability to bargain here, looking at the statutes that we've been looking at, they don't fit within that criteria. There's been a lot of discussion about this Hilton case and all of that. Well, Hilton was licensed to teach. That was a different situation, and it was under a different statutory framework at that time. School psychologists have a school psychologist license, but these are different things that we're dealing with. So if you look at the actual definition of teacher in 15.1-16, it doesn't really fit. And one of the reasons why we know this is if we go back and we look at the legislative history that took place when the statute was rewritten and addressed in 2001, we can see that. And I want to make a point. In the legislative history, the committee makes it absolutely clear that when the original first draft of the legislation was drafted, it was first drafted by Legislative Council, which is a series of attorneys that work for the legislature. It was then provided to the North Dakota Education Association for their comments and their edits that they wanted to see in it, and then it came back. You can find that in the legislative history. And when it came back, there was a request to insert additional language explicitly stating that school psychologists and other people were within the definition. There was a dispute within the committee. The School Board Association said, we don't agree with this. This is different than what it's supposed to be, and you're trying to broaden this or make it different. And the commentary during the legislative history was ultimately, well, I think this will have to be resolved in January. Meaning when the legislature goes into session and they enact this law, that's when it's going to have to be addressed. And it's important to focus on and recognize that the attempt to list school psychologists and other different classifications and all of that did not make it into the statute. That has to have some form of significance. Now, the comparisons to the other statute, 15.1-13, that does address teachers' licensing that Mr. Geierman had pointed out, it is not a fair or accurate comparison to take a definition from one statute, which explicitly says in that statute that it applies to this chapter. The very first language in those statutes says that it applies to this chapter. Then if you go into the licensure statute that we were looking at, the purpose of the licensure statute is to enact a framework of how licensing and different things are going to work, also relating to complaints and different things like that. So there needs to be some way to identify folks working within the educational system and those sorts of things. But if you flip back to what the purpose of the collective bargaining statute is, that's to narrowly identify which classifications or which individuals the legislature in North Dakota has given the right to collectively bargain. They're not the same two things. And Mr. Geierman is right. There was actually a change in the law in 2007 when those classifications were listed in that statute, again, the different statute that is not for teachers' negotiations. And the legislative history says that the only reason behind this was the Attorney General, that office recommended a change to make it more clear with respect to that particular chapter. It didn't have anything to do with teachers' negotiations. So recognize that there are two different purposes between those statutes that they're dealing with. You can't draw from one definition from one and trying to apply it to another, because there's a problem with it if you do that. In the statutory definitions in the chapter 13, the chapter regarding the teachers or the licensing, there's a big paragraph. The very first paragraph in there relates to administration. And in there, or what administrators, and in there, it broadly states that administrators encompass special education unit administrators and different things like that. Well, none of that applies, and none of that is the same back in the teachers' negotiation statute. Recognizing that there are two different purposes for this thing. This is not an identifying of anything to do with the teachers' negotiation statute. Responding to some of the particular points, I would again respectfully disagree that there's any form of past practice or anything dictating that that the district considers or treats or has always believed these people to be on the negotiated agreement. Again, I think this gets back down to the fact that someone is paid in accordance with the salary schedule doesn't mean that that individual actually falls within the bargaining unit there. You could pay other people in your district in accordance with that salary schedule if they had, you know, the educational lanes and all of that. That would not make them in the bargaining unit. So if you're going to look at this from a perspective of past practice, there's a couple points to make. This is an issue about whether or not the legislature actually allowed these individuals to have collective bargaining rights under the statute. Not whether or not a past practice has allowed somebody to bring another group in. Because if the past practice thing worked, you could see districts encompassing other classifications and other classifications. And then all of a sudden, the legislature's parameters on what the legislature has defined for collective bargaining rights in public sector North Dakota has been eroded and been changed. And that's not how the statutory framework is supposed to operate. I'd like to make a point with respect to the school counselors, the discussion that council had identified coming from March of 2020. What happened at that time and what the board minutes reflect, all of that was not a putting the school counselors on the negotiated agreement. That was specific to they were requesting preparation time and they were granted preparation time. That's a different thing than saying you're in the negotiating unit. We've been talking a lot about 2001 and whether or not there were changes made to the law and all of that. And without a doubt, there was a change to the definition of teacher that was made in 2001, which took it from a broadly encompassing teacher means and includes certain things to tailor it down to say that teacher means these specific things. Now, I will acknowledge there is a statement in a 2006 case that the intent wasn't to make substantive changes, but the reality is when the legislature codified Senate Bill 1045, which is ultimately the 2001 teachers negotiations, the 380-some pages of documents here, there were substantive changes made. There maybe wasn't the intent when the beginning took place to rewrite the statutes, but it did happen. And at the end of the day, this is a question about whether or not the North Dakota legislature has allowed and given school psychologists the right to collectively bargain under the statute. And if you look at the actual statutory language requiring the individual to be licensed to teach or approved to teach and do more than 50% teaching as opposed to other duties, that's when it can apply. They're not licensed, these are not folks that are licensed to teach. This is a different situation. If this was something where they were indeed in the bargaining unit, one would think that the negotiated agreement would have actual terms that specifically apply to the school psychologist as opposed to things that relate directly to the teachers and all of that. Specifically for work rules and what the hours are, different things like that. So I think it's important at the end of the day to not get brought into if we've paid them similar or based on a schedule, that means they're in the collective bargaining agreement or in the unit. The question is more nuanced. The question is more fundamental. Does the legislature give these individuals the ability to collectively bargain? And respectfully, I think the answer to that is no, they don't. I think there was an attempt to get them the ability to collectively bargain back in 2001, but it didn't happen. And at the end of the day, I recommend that you deny this grievance.
Thank you, Mr. Thompson. Mr. Geierman, do you have any replies?
Can my screen go back on? Do you expect me to push that button? Oh, good. Just a couple of comments, board members. Mr. Thompson indicated that tried to split the hairs in regards to these contracts that have been issued, and I told you I've seen 57 of them. If you want to see them, I can bring them out for you. So the contractual basis between the school psychologists and the Fargo School District had to come from somewhere. And I get back to Superintendent Gandhi's letter to Mr. Kraft. I am upholding the decision to move the school psychologist from the negotiated agreement. It's not my language, it's his. From, that's where they were. Now we're taking them off. Has the legislature given the right for school psychologists to be part of the bargaining unit? The answer to that is yes. And more importantly, has this school district acknowledged for over 20 plus years that they were part of the unit? The answer to that question is yes. So why all of a sudden, 22 years after the law has supposedly changed, has the light bulb come on in Fargo? And we're going to take them off. When no other school district besides Bismarck has ever done that. There's a process to be followed. That's all we're asking you to do, is to follow the process. But unilaterally changing the game is not part of the process.
Thank you very much. Anything else? Any other comments?
Just one comment. With respect to the FEA's position that, for 22 years or for some level of years, these folks have been on the negotiated agreement. I guess I would ask, why wouldn't the FEA have grieved in that time differences for the terms and conditions for the school psychologist as opposed to the negotiated agreement? If there was a belief that the school psychologists were indeed within the bargaining unit and the negotiated agreement actually encompassed them as opposed to them getting some of the benefit from it, wouldn't we have expected the FEA to make and file a grievance over any of that? I think that speaks volumes as well, too. Thank you.
Thanks very much to both of you for your presentations. Board members, I would open it up to you for questions of either of them, or administration if that's helpful. Yes, Nikki?
How many can we have?
I have a
I've
list
got a
too, so
few.
just.
I've got a few, one at a time. All right. So, Mr. Geierman, how is Bismarck able to get away with it when nobody else in the state is, if that is the perception?
The Bismarck Education Association was approached with a package and they took it. They agreed to it. It wasn't unilateral. It wasn't forced on the Bismarck Education Association. They agreed to it. Nobody's asked the Fargo Education Association if they've agreed to this. This was unilaterally forced on them. That's what caused the grievance.
Okay, thank you. And then my next question goes back to North Dakota Century Code 15.1-16-15, I guess it is. I keep seeing that the revised definition of teacher is clear and unambiguous, since it is consistent and fully exhaustive that a teacher only includes a public school employee licensed or approved to teach by the Education Standards and Practices Boards and employed primarily as a classroom teacher. I don't believe any of these folks are employed primarily as a classroom teacher. So how does that play into this?
Are you asking me? Okay.
Either
I'll
one
answer
of
that.
you.
You turn my screen back on? I'll show you. There's the subsection 5, right? That's what you were referring to, Ms. Gullickson? You combined all of those into one. There's an or in there. See where the or's at? Don't read the memo. Read your screen. There's two categories of teacher. Public school employee licensed to teach by the Education Standards and Practices Board or approved to teach by the Education Standards and Practices Board and employed primarily as a classroom teacher.
And
There's
it's
two
the
categories.
and. It's the and that I'm stuck on.
The "and" from an English perspective modifies the approved to teach.
Well, it says approved to teach by the Education Standards and Practices Board and employed primarily as a classroom teacher.
That goes to the approved part. The other one is licensed to teach. And then when you combine that with this, where the profession of teaching means the services provided by a school psychologist,
They're still not employed primarily as a teacher.
you're combining the categories, I'm not.
Okay.
That's my answer.
Then my other question, my last question would be, you had said there were two categories and you're either a teacher or an administrator.
Ms. Gullickson, I never said that. The Supreme Court said that.
Okay, well, let's say they did.
They did.
Okay, all right. My question has to do with who manages the IEP and 501 and 504 meeting? Is our school counselors a part of that?
I'm not qualified to answer that question.
Do administrators normally run those?
You're asking me questions I don't know the answer to, and I learned a long time ago that if I don't know the answer, then the answer is I don't know.
Fair enough. My understanding is that school counselors are often asked to step into that role because an administrator is not available. So what I would see is that they skew more towards the administrative side than a classroom teacher side.
Do they spend 50% of their time doing that?
I would say closer to that than being a classroom teacher.
Okay.
But we both have our opinions,
We
but it is a
s-
fair point.
We certainly do have our opinions.
Okay.
Can we go Mr. Thompson and then we'll jump to Greg? Okay.
Thank you. I just wanted to respond to a couple points raised by the question there from the board member. I guess, one, in looking at what you have in front of you right now, which is again the section of the Century Code that relates to teachers licensing and all of that, take a look at 3 and take a look at the very last word. We're talking about the profession of teaching, yet it includes administrators in there. It's a different thing that we're talking about here. And if you, I guess I have a copy of this right in front of me right now, but the very first sentence in 15.1-13-01 definitions is for purposes of this chapter. That's limiting language saying for purposes of the teacher licensing statute or chapter. Just like 15.116, which is the collective bargaining statute, the very first thing you see under definitions is as used in this chapter. These are specific terms specific to these chapters. I would also, if I could, and I'm going to ask a favor right now of Mr. Geierman, if we could go back to the previous statute that you just had up there, if you wouldn't mind, the 15.1-16-01.
Oh, I'm sorry.
There we go, 5, thank you. When we're looking at, where it says teacher means a public school employee, going on like that, the "or" that Mr. Geierman pointed out there really doesn't modify the question or apply really here. We're dealing with a situation where school psychologists, unless they're independently licensed to teach, I will acknowledge that you could have a situation like that, but school psychologists are not licensed to teach or approved to teach in a classroom. You're not allowed to have that individual go and teach a class. That's part of the problem with trying to shoehorn this definition in here. It doesn't fit. Thank you.
All right, we'll bounce to Greg now.
Well, Mr. Thompson took what I was going to say is I noticed a conflict between those two sections of the Century Code saying that you're either a teacher or an administrator, which I don't know how that works for other people in the building. like paras who are certified in their own right. But let's assume there's a dichotomy of teacher and administrator. Yeah, it gets. I I, I was had found that section of the teacher licensing chapter that lumped them both under the profession of teaching, and I don't I don't like that conflict existing.
I have a question, just because it's come up, and I apologize that I'm not clear about this, but are our school psychologists public school employees licensed to teach? No, okay, yes. Yeah, Tara?
So I think it's important that the board understand the distinction between a school counselor license and a school psychologist license. The license that a school psychologist has from ESPB is a limited license that only allows them to practice school psychology. At no point can they go into a classroom and substitute teach for a teacher who is not there. A school counselor can. So continuing to refer to them in the same sense as a school counselor is an incorrect analysis. So they have a license to practice school psychology.
Yeah, Seth?
I just have a little bit of clarification on the legality of this. I've heard it said that that violating state law, and that Bismarck has done this, and they've done it by agreement. Even if it's done by agreement, if it's against the law, then isn't Bismarck still breaking the law? And I would look to either attorney for clarification on that point, because it seems to me that regardless if you make it, if you make an agreement, if it's against the law, it's still against the law.
I guess I would respond in the limited amount that I can. I'm not familiar with Bismarck's situation, but something I'm going to look into. I'm not familiar with their arrangement there.
Demal?
Well, I guess my question was taken by Mr. Thompson there from the beginning. I was thinking, I had a lot of things that were on my mind. And I don't think that that question was answered. So if this was an issue, this grievancy was an issue since 2001, as you all look into this, and I'm just wondering why this 2023, if you feel that Fargo Public School has been violating a lot of grievancy in the past couple of years, why 2023 that you have to brought up these issues now? Why didn't you brought it in before?
The issue is whether or not the school psychologists are on the contract. Since 2020, since 2001, their contracts have always been issued pursuant to the negotiated agreement. You could look in the salary schedule and pinpoint what their salary is. Now, this summer, they were issued contracts, which number one, we think violates state law. Then number two, that new salary amount has nothing to do with the negotiated agreement. That's where the violation comes in. Does that make sense? Does that clear up your question?
Sorry. I just wanted to really understand, because we're going through definition after definition, and I did see that century codes or there are a couple of definition has been changed. And then also too, as Mrs. Tara said, there are, from my understanding, of course, there are school counselor that can teach. And then also too, there are school counselor that can just basically discuss with the student about the issues that are going on. That's I'm just saying it a little bit. But I just really want to understand if this was an issue before, why brought it up in 2023?
It was never an issue.
It was never an issue.
It was never an issue until they unilaterally changed the contracts that were issued to school psychologists to a different amount that didn't coincide with the negotiated agreement. So there was no violation from 2001 to 2023 as far as the FEA was concerned until this summer when they issued contracts off of the schedule, off of the negotiated agreement. That's the violation.
Thank you.
Katie?
I think following up on Namal's question, so my question is for the administration then, is why were they moved and why was the process that Bismarck used not considered or followed?
I'll just kind of share a little bit from my perspective, and I'm going to, Katie, hopefully take your question, also probably answer my words that were kind of referenced earlier as well. I think this ultimately comes down to, unfortunately, a linguistics battle, right? And that's what it is. I want to first just start by saying, like, grievances can be contract violations or grievances can be interpretations of contract. Administration is viewing this as interpretation of contract, so I want to first start by saying that this isn't a positional dichotomy between the FEA and administration or the board. I don't think this is a positional issue. I think this is a matter of, like, what is the right interpretation? We have a history of and a practice of using the term on the contract or off the contract. And what does that really mean? That was actually part of the conversation that we had when this issue was brought to me at the level 3 grievance with the FEA, because it has been said today, and the common assumption is that if someone is paid at the same salary schedule as a teacher, they are on the contract. And when you use that phrase, the unfortunate part about that is that you're only talking about the salary schedule provision of the contract, because administration's perception is the term on the contract should be used. If that's the term, then every provision of the contract should apply to you. Had that been the case, then our school psychologists should have been working the same length of day, which they weren't. That's prescribed in the contract. There would have been the concept of prep time. There would have been all these other pieces that just aren't applicable to their role because they're not in that role of a classroom teacher. It gets more convoluted because North Dakota ESPB recognizes every licensed educator as a teaching license. But having a teaching license, because that's what ESPB calls the licenses for a variety of positions within the field of education, does not mean every provision allows you to be and perform the duties of a classroom teacher. So there's a difference there as well. So in my communication back, yeah, we were used to using the term on the contract. The reference is supposed to be to the salary schedule, but it was never our position that counselor or school psychologists, in the past have received prep time, that they were following the same length of day contract provisions that our elementary and secondary teachers provide. They work for the equivalent of 5 out of 8 periods or whatever those pieces of the contract are, right? Those pieces are specific to the role of a classroom teacher. This happened to be the application of a salary schedule that was being used. Absolutely, Fargo Public Schools in the past has used that salary schedule for school psychologists in the past and other positions. And we've also had a very consistent HR practice of when we distribute our salary schedules. But this is the first year, at least in my time here, that we have determined compensation and on a different timeline for other employee groups that were not part of the negotiated agreement as well. So that is just a timing of when we did that work as well that happened. And I think one last thing I just want to share here is also just a little bit of when this grievance was brought to me for consideration, I fully recognize that both sides are presenting various interpretations on number 5 that you see in your screen in front of you. And whether it is, what's the modifying preposition here? Is it the or is it the and? I think either one doesn't matter in my assessment, simply because I think that even if you use the or as a modifier, a school psychologist license does not mean that that's a license where you're approved to teach. And I think that word teach is different than the function of a school psychologist. Even if they have a teaching license, that does not mean you're approved to teach, as my interpretation there. I also want to share that fully recognize that it's not about RUPAC's interpretation. That was for my assessment. I did ask at the time that this was brought to me that because this is up to a legal interpretation, if the FAA would consider waiting on my response till I got a response from the Attorney General's, so I can have that right interpretation. But we are prescribed to follow a certain timeline in which I have to give a response. That wasn't provided there. So at the end of the day, I think everyone here wants to do what's right for our employees. There was a group of employees, our school psychologists, that brought something to us that really wanted to make sure that their work is competitive with the market. And there was a reason where you look at comparable school districts. So we're just trying to do the right thing for our employees. And if it comes down to a legal interpretation of what the spirit of the law is, then I think let's look at past practice, let's look at past legislation, which I think in all of these pieces, based on the information that we have, does not show that they are approved to teach in the classroom. And if we can go seek an opinion if we want, but at the end of the day, we want to do what's right for our students and our staff. And our staff, there isn't, it's not about not, if we're violating the law, then the judge would tell us and we would correct that piece. But this wasn't an employee grievance that was brought to us. Our employees came to us at requesting that change because their profession was significantly different in their salary schedule compared to neighboring districts and in their position. So that's the change that we made, just to stay competitive for that employee group.
I have a question. So, and I think, yeah, so chapter 16 is in front of our screens right now. So under the subpart 2, and I'm looking at B, and there's a part that says, or a history of common representation. Let's just assume for my question that the school psychologists were on the agreement. Like, does that history of common representation, like, can somebody kind of share like the thrust of that and like what that means for a negotiating unit?
Could you scroll down
I have a
just a
different
shade
statement
on
to
that?
make, so I don't know about that one. Scroll which way?
Down, just so we can, nope,
Oh,
other way.
yeah.
Thank you.
So I'm looking at 2B, highlighting or a history of common representation.
I guess, if I may.
Yes, please.
One point I would make right away is, has there indeed been a history of common representation? Because the terms and conditions for the school psychologist haven't been bargained. The salary schedule that applies to them has been applied to them, but their length of day, their, other working conditions and all of those sorts of things, I don't necessarily have, been applied to them, nor, not saying I have all of the history. I've not seen proposals on behalf of school psychologists in any of your collective bargaining rounds, I guess.
So I wanted the assumption, like, just for the purposes of my hypothetical, like the assumption that they had been, because I'm like, if this issue comes up again, I just want to know, like, there's been a lot of history or a lot of arguments about they were on it or they weren't. And I'm just trying to get like a temperature read on if 2B matter. Like, does that matter? Even if they didn't have to be on it by statute or were permitted to be on it by statute, if they don't meet the definition of teacher, if there's a history, like, how do we interpret that part of the statute?
One additional comment, if I may.
Yeah.
I think it's important to recognize, too, that when we're talking about in the public sector in North Dakota, teachers' negotiations, there's the recertification process, for, the negotiating unit and all of that. So you could see where that would be perhaps relevant when you have a group of teachers that are negotiating and then they come in for the next year, seeking to be recognized and all of that with that same group and all of that. But the fact that North Dakota does this on a rolling basis and makes the Education Association recertify that it represents the groups and all of those sorts of things on a routine basis, I think plays into that.
Does anyone know if our petition specifically, like, does it list like all, like certain employee groups? It does, okay. Okay, I think I saw Tara go, no.
No, I didn't hear the question, so I was asking Tara.
Oh.
Sorry.
Does the petition that we approve as a board for the negotiating unit, does it delineate which, like, does it say like
specifically-
teachers, librarians, schools, does it say?
It specifically references the statutory definition of teacher.
Okay, which is so crystal clear.
You're welcome.
Okay, thanks.
I think the other thing that I would point to when you're looking at B is we're still talking about the definition of teacher, right? There's two parts to that. A talks about administrators, B talks about teachers. We don't agree that they're teachers. So regardless of whether they have a history of common representation, I think you have to look to the fact of whether or not they even fall within that teacher definition.
Yes.
Madam President, can we go back to Hilton just for a second?
Sure, we can.
The Hilton case said you are either an administrator or you're a teacher. The statute, right in front of you right now, you're either an administrator or a teacher.
Could you give me the paragraph site? I have that case in front of me.
Hilton,
Yes.
I'll give you the one out of Kenmare. Okay, no, the
No, you
Kenmare
were
case, I just popped the Kenmare case up, right? And it's, hang on. Or no, I know where it is. It's in your lawyer's memo. Even better. It's right there. We believe that the purpose of the employed primarily as a classroom teacher criteria was to distinguish a teacher from the administrator. You're either an administrator or you're a teacher, not because NDU says so, not because the FEA says so. It's because the Supreme Court says so.
What are custodians?
They don't get to bargain. They're not certified by ESPB.
What about paras? They have certification standards.
I don't know if, I don't think paras are certified by ESPB.
Yeah, I don't know if it's necessarily ESPB, but they are certified in the state of North Dakota.
But Mr. Clark, that's the linchpin. That's the linchpin to the entire argument is you have to be certified by ESPB. And school psychologists are. I've showed you the statutes. That's the old one. There's the new one. There's the newest one. The profession of teaching includes school psychologists. It doesn't say paras, it doesn't say custodians, it doesn't say anybody else. So when the legislature created this statute in 1969, in the wake of the Minot teacher strike, they made two categories. You're either an administrator or a teacher. Fast forward that to 1999, when the Hilton case is decided, the Supreme Court says the same thing. You're either an administrator or you're a teacher.
And if I may,
Go ahead, Dave, I'm sorry.
okay, I'm sorry. Number 3 also includes administrator. So profession of teaching also includes administrator.
And I'm not saying it doesn't, but why are you looking at administrator when the issue that involves school psychologists that are 2 words away from that?
Because I'm not convinced that they are a teacher. Their duties take them closer to administrator and they step into the shoes of administrators at any given time.
But the test for administrators, coming back to the test for administrators. Up in number 1, 50% of your time has to be an administrator. And by the way, you have to have an administrator license.
Well, and so we've got another issue because it says a classroom teacher has to be at least 50% or has to be a
Where does it
majority.
say that?
It has to be a majority of what they're doing.
Where does it say that?
Okay, primarily, so that's more than 50%.
The legislature used 50%
That'd be
up here.
51%, right?
Yeah, and that's why you go to the Hilton case.
But we were told the Hilton case was older before changes were made, so how can we go back to the Hilton case?
Well, that's why we have a disagreement.
Yes, Mr. Thompson.
If I may, I think it's important when we're talking about certain, using the terminology certified or certified as a teacher, we're we need to be careful with that. I mean, the statute that was involved in the Hilton case was said that all public school employees certified under 15-36 and primarily employed. It didn't say as a teacher like it does now. It's right now, it's you have to be, licensed to teach or approved to teach. There, it was just saying you had to be certified under this chapter. There was no statement of teach in the statute at that time. That's why it's important when you look at a case from long ago, while it may be instructive, we also have to take a step back and look at what the actual statutory framework was that it was working with. And that's where I think there's a distinction here.
I just want to clarify, it looks like in the Hilton quote that it did reference primarily as classroom teachers under 15-36. I'm reading paragraph 6 of Hilton right now. I get that it's different, but I think you said there was no mention of teacher.
And maybe I should have been more clear, in the kind of the previous clause, certified under 15-36 and all of that.
I'm so sorry. I have the worst habit of looking this way. I'm going to turn this way now. Okay. Namal, then Seth. Okay, I'm sorry. Seth.
This
Yep.
one of decisions this board makes has effects. I kind of want to bring us back to why we're all here, and it's to serve kids. We have problems with mental health increases. School psychologists help with that. If we go back on what administration has done, because I believe that administration is doing this so that we can make sure that we retain these school psychologists that help our kids, if this happens, who suffers? Is it our students? If we can't hire the school psychologists to serve our students, don't the students suffer? I know we're talking a lot of legalities right now, but I just want to bring us back to that point.
Katie?
So I think I think we've kind of reached a point where we're going in circles about what we agree and disagree on in terms of. Oh, okay. You get to talk next, if Melissa says it's okay. I think the bigger problem that I have here is why wasn't a similar process followed that was done in Bismarck? Because if I remember correctly, the only reason we ended up here with the special ed thing was because the FEA was upset about this. And so I feel like there's this huge lack of trust and respect, it seems like, in this room, and that's my concern right now, is that why didn't we follow, if another district was able to do this with their teacher, why didn't we do that too?
The answer to that, may I answer? Sorry. The answer to that is because we were approached by the school psychologists. Like, this wasn't an issue brought to us by the FEA. I think the entirety of the 100% of the employees that are in this group know that this is happening. They brought this proposal to us based on the research that they did. And again, if you're working and operating from a mindset that your length of day has not been applicable or other provisions of your contract hasn't been applicable, I don't think that there's a single employee that we believe, like, you are tied to the contract only for salary, but no other provision of the contract's tied to you. That's not how we operate. It's either you can be an employee that's not on the contract or not, but you are following the teacher salary schedule. We've done that, and we realize it's time to make a market adjustment like we've done for other employees. So that's the difference. I do want to just share one more piece of information too. A consideration that I had when providing my response at that level, knowing that it would go to the board if there was a disagreement, was also like, if this goes the distance, right? At the end of the day, this is a legal interpretation, and I get that. And if it's a legal interpretation and a court says, hey, we interpreted something wrong, then administration would say, okay, let's fix our wrong interpretation. But we would still go to the FEA and find the right, if our process is wrong, I don't believe it is, and still advocate for our staff that came to us, because our first and biggest goal is to take care of our students and our staff. And when the staff directly come to us and say, here's a big market inequity for our position, we're going to try to meet their needs. So my goal at the end of the today is not to win an argument. It's not to win an interpretation. It's to do what's right for our school psychologists who are not under the previous salary structure that they were provided, who are not competitive compared to our neighboring districts and to others in their position. And I will continue to advocate for them because that is what they deserve to be employees of Fargo Public Schools. I am, and based on the information I have, without the ability to get an Attorney General's opinion in the short time I was able to ask to provide a response based on the legal analysis that's been shared with me, of the belief that we followed the right interpretation of North Dakota Century Code.
If I could answer that quickly as well, from Bismarck, what they have done is they went to the table and negotiate that situation where they could remove them from their agreement, and that's how it was handled, and that was kind of what I guess the process that would be expected to use as well. And just if I go on as well as past is about the limited license that the school psychs have, that's not accurate. If you reach out to ESPB, there is no such thing as a limited license. They're just licensed through ESPB. And so, and I asked them directly, if they needed them to be a sub, could they be a sub? And they can be a sub in the classroom. There's no restrictions, there's no law that's against it. And I reached out directly to the director at ESPB, and they told me that they're licensed like a counselor and somebody else to be able to fill in for a position if they need to be in there for us, like a class period or for a day or whatever. They don't recommend it, but it's possible they can do it. So that is just to clarify that statement as well.
Okay, thank you. I think Greg was next in line.
So I actually have some information directly related to that. So one fun thing that ESPB and their website allows you to do is look up any educator and find a list of things that they are qualified to teach. I didn't know that until today. I looked at my wife. She is qualified to teach, I don't count, like 70 different courses. They all have a different code because she has like, I guess, a normal teaching license plus library certification, what have you. I looked up one of FPS's guidance counselors. There's a much smaller list of courses they're qualified to teach. It's 6. And interestingly enough, I looked up a handful of FPS school psychologists and school psychologist interns, and their credentials list 3 ESPB courses they are qualified to teach. That is the language that is on the ESPB website. Anyway, also, I'd like to maybe mention our school psychologist job description that our director of human capital sent me today. And I'm really conflicted by it because in the essential duties and responsibilities, I don't know if I could, there's maybe 10 different bullet points for essential duties and responsibilities. And I don't know if any single one of them could be construed as teaching. They're basically, they have lots of meetings, they do a lot of assessments, and then they do reports and meetings based on those assessments. Does that sound about right? Yeah, all right. Well, that's what the job description says. But also in the job description, under other skills and abilities required for this position, it says they need to have the ability to apply knowledge, research, theory to instructional programs. And they have to have the ability to plan and implement lessons. And so that sounds an awful lot like teaching to me, which is interesting that it's not included in their essential duties and responsibilities. So that has me slightly conflicted. And I guess the last thing I want to say is that to me, it seems like we probably wouldn't be here if contract negotiations had been done in like May. I think we would have issued a contract, a bunch of people would have signed it, and psychologists would have had the same salary schedule as teachers. It just seems like a weird, maybe unfortunate case of timing.
Yes, Dr. Gandhi?
Greg, thank you. I just also wanted to share that timing, I mean, I think timing is a big piece of this too. Negotiations, I believe, started February or so last year. Still this year, yeah. After negotiation topics were exchanged, administration was approached by the school psychologist group. And as I shared before, we believe that the individuals that approached us and that we interacted with were representative of the majority of, or if not all, the employees that sit in that employee group. So if the school psychologists were also under the impression that they fall under the negotiated agreement and all the provisions therefore, wouldn't they have gone through their channel, the FEA, and wouldn't that have become a topic at negotiations as well? So these are different pieces that we considered as well, and that didn't happen. There isn't a school psychologist that signed on to this grievance. They didn't go through the FEA for that process. Much after it was started, they approached administration. So that just shows you the mindset that all of us have been operating under.
Yes, Namal?
Okay, I'll make this one quick. I believe that first and foremost, we are all here because of our kids, specifically our students, and I do have kids too in the Fargo Public School. I seen this coming because of the fact that I feel like we are not working together as a team or as a district. Because there is a lot of words that are being said here, respect, or that's what I've been hearing. We are not being respected enough, and as an educator, that we should be not required, but to work together as a team, because we want our kids to be educated, to be counselor, to be somebody someday. And to me, I find this very alarming. I don't think we should have come to this position from the beginning, because this is just not fair for our student in Fargo Public School. We should be working together as one. As an individual from a background who came here in this country as a refugee's child who doesn't speak English, and the fact that I get to sit here and listening to a community that have a privilege to actually turn people life around to do better in life, it's kind of disturbing me to sit here and hear certain thing about, oh, this should have been done this way, or the definition of teacher or the administrations. We should be standing for educational system. For me, it's very disturbing, because this is what makes public education to be looked at as a vehicle for other people to exist. I mean, for them to remove their kid from public school. This is like a reputation where we're giving other people a voice to say, you know what, public education is not respected anymore. This is how I'm looking at it from a different perspective. You all have a privilege to really make public school better. But here we are as an adults arguing about the definitions, arguing about negotiation agreements. I find this is very disturbing. And before you really answer your question, I think you really need to ask yourself, why are you here? Are you here for the kids, or are you here for yourself as individual? Or are you here for public education? What are you here for? Because to me, is I'm here for the student in Fargo Public School and for all of those parents who actually elected me to be here, not arguing about negotiations for certain, just because of definitions and certain thing like that. Don't get me wrong, I do understand exactly what you are talking about, but we actually making public education look bad. I'm sorry to say this, but this is what make public education look bad, because we're arguing with certain things that shouldn't be argued. This should have been just done back in the background, and we shouldn't even be over here. Please, what I'm asking you all, let's work together as a team to make our school better. Let's make our academic achievement much better for our kids, not thing like this. Thank you.
Thank you, Namal. Yep. Mr. Garman?
The people I represent and the teachers I've represented over the last 36 years have devoted their lives to children. They do not question your commitment to children. Do not in any way, shape, or form ever question their commitment to children. They went to school, they got certified, they get up every day to teach the children. They respect your commitment to children, respect theirs. Never question the fact that they would put unionism over the welfare of children. One of the things you teach children every day is to follow the rules. This grievance is about following the rules.
Yes, Dr.
Thank you.
Newman.
I'd like to make a motion to deny the Fargo Education Association Level 3 grievance to the Fargo Board of Education per the negotiated agreement regarding school psychologists.
Second.
All right, moved by Dr. Newman and seconded by Nikki. Any further discussion? Yes, Greg?
So I guess I have one maybe weird final question. And I know a lot of people have kind of come back to the fact that Bismarck doesn't have psychologists as part of their bargaining unit. And I'm wondering if, and you know, I apologize for putting them on the spot, but would the FBA ever remotely entertain even having a conversation to remove psychologists from the negotiated agreement?
Mr. Clark, as a member of the board's negotiations committee, I think you're well aware that any topic that's brought to the negotiations process, whether by the board or by the FEA, will see its time and diligence from all sides in that process.
So I guess maybe what I'm getting at is, are we maybe potentially saying that it wouldn't be illegal to do so?
We would have to give it its time, and I don't have an answer to that.
Well, I guess maybe that would be a question more for your counsel, is that it's not necessarily illegal to take psychologists off the negotiated agreement.
I'll defer to counsel, but I can't help but take the moment to reiterate how much we work together with the groups that we represent. Teacher is a broad definition. It involves a broad category of people doing important work in our schools. And this negotiation cycle, we addressed needs of special education teachers. We addressed needs of elementary teachers. We've addressed needs of other groups of teachers throughout the negotiations process. What the FEA does is turn to the members who fit those categories and have internal dialogue to see what makes sense for those employee groups. I would expect administration, if they are petitioned from a group of employees, to bring those concerns to the negotiations table, where we can have the dialogue and have the discussion that needs to be had. Would a question of legality come up? Possibly. I don't know what that proposal would look like. I don't know exactly what Bismarck did. We would have a lot to look at, certainly, and from an FEA standpoint, we would be turning to any school psychologists who are FEA members to have that dialogue along the way.
Yes, Mr. Thompson?
Thank you. I too do not know the backstory on Bismarck, and this is a more broader question that has to be looked at, but a couple of things that come up to me immediately in my mind are to negotiate a classification or a group of people out of the bargaining unit. They first have to have the right to be in the bargaining unit. And this next statement is more of a rhetorical question because I think I know the answer, but I'm not completely sure. How could a union and a district negotiate to, let's just assume that they have the right to be in the bargaining unit. Let's assume that the FEA's position is correct and that they are within the definition of teacher. How could a district and a union then negotiate to take away the statutory rights of those individuals to collectively bargain? That's something that in my mind, I think I'd have to try and work myself through.
That's kind of my point of what I stated earlier, or question I had earlier is even if Bismarck did work together to take them off their contract, if that's not legal to do, it's still illegal to do. And so I keep coming back to the point of, or at least in my head, if Bismarck did it and it's illegal, then why is Bismarck still able to do it? Because it's
Dr.
legal.
Gandhi?
And I apologize, I might just be asking just another version of the same question, but Seth, if you know the answer, just from my own learning too. The right to bargain as prescribed in Century Code, is that a choice? Or if you fall for that representative group, you're part of the collective bargaining process? And I guess where I'm getting with my question is, for the purposes of my question, I'm only going to use first grade teachers. So we have an example of someone that truly is in that classroom teacher without debate. Can first grade teachers come to any school board in North Dakota and say, through the union, through the process that's prescribed, and say, this group no longer wants to be part of collective bargaining? Well, because we have teachers that are not part of FEA that are still subject to what is negotiated, right? So under that same premise, if the teachers, if the psychologists were and should always be part of the negotiated agreement, Bismarck wouldn't be allowed to do what they did, right? Because we can't do that for any other employee group. Am I correct in that assertion?
My belief is that, to answer your question on your example of the first grade teachers, I don't think that they could. I think, if we're dealing purely with teachers, when the union negotiates a contract, it covers all of the people in that classification.
So even if the FEA came to us and said, the first grade teachers of Fargo Public Schools no longer want to be part of this agreement, those first grade teachers would still have to go through a collective bargaining process and maybe devise their own separate contract or something else, because that is not an option for that employee group, correct?
That's my understanding.
And from the information that's been shared with us today, when Bismarck, under the premise that they moved off the contract, there's no other negotiated agreement that they're still collective bargaining. So doesn't that just demerit the fact that they had that collective bargaining, that they were part of that group to begin with?
Tara?
I do want to note for the board members that prior to this happening, I did contact Bismarck and walk through the process, and our conversation centered around the fact that Bismarck too, in that conversation, indicated that they did not believe that school psychologists met the definition of classroom teacher.
Yes, Dr. Condi.
And my only other question would be for the board. Like I said before, this is a matter of interpretation, and should the board decide that the school psychologists are to remain part of the collective bargaining process, I think administration would seek clarity from the board if your interpretation means only for salary or every provision of the contract, because we don't know how to systemically provide that delineation, and we have to protect the system against that interpretation for every employee group that may or may not be impacted based on the vagueness of the language.
All right, if there's no further comments or questions, Anne Marie, for all of our clarity, would you mind reading the motion once more, and then we'll do a roll call vote, please?
The motion on the floor is to deny the Fargo Education Association Level 3 grievance regarding the school psychologists.
Thank you.
Newman,
Yes.
Christensen,
No.
Clark,
No.
Day,
No.
Gullickson,
Yes.
Holden,
Yes.
Berkland,
No, motion fails, and I believe the grievance has been upheld. Is that? Okay, so we are adjourned.